Appearance on Dion's Daily Dose does not imply endorsement from or by any candidate or guest. The views, thoughts, and opinions expressed by Dion Bergeron or Dion's Daily Dose are his own and do not represent the views, thoughts, and opinions of any guest. Material and information presented is for general information purposes only. The Dion's Daily Dose name in all forms and abbreviations are the property of its owners, and its use does not imply endorsement of or opposition to any specific organization, product, or service. If you'd like to support the show, please visit our Patreon at patreon.com/Dion's Daily Dose.
Oops. All right. It would help if I got my microphone ready this time, right? Hi, guys and gals and everything in between. What's up?
I don't think it's on. I think it's on green. It's on red.
No, this one's
okay.
Yeah. No, you're good. I appreciate it. So we have different microphones, and one microphone has a red light on it if it's not on, and this one has the RGB, so it's,
Okay.
But yeah, we're good. I appreciate it. So here's Shawn.
Hello.
He was trying to tell me your microphone's red, and I'm like, yeah, it's got the RGB. The whole thing's red.
Good to know.
Yeah, I appreciate it. All right, so today we're going to look at this whole TikTok ban crap that the Supreme Court heard the arguments from. We're going to break those down and get into it a little bit and see why they made the decision that they did. Because I'll be honest, I kind of thought they'd uphold the ban. I was afraid that they'd uphold the ban, but I didn't think it would be unanimous.
I didn't either.
Yeah, I thought that there would be a 5-4 split. And
I thought it was going to be 8-1 or 7.
Did you?
2,
Okay.
Yeah.
All right. Anyway, I'll stop babbling and we're going to get into it here. Our first clip is from the 127 mark, which I'm like way off. I don't know how I messed that up. I think I was looking at something else. Okay. So getting it ready, and it's actually Noel Francisco that is going to start. I looked him up. He's the attorney that's going to be one of the attorneys that's argued this case. And he's a former Solicitor General, which I found interesting. So here we go. We're going to dive right into this. If I can find the right one. That's not it. That's not it. That's not it. Where'd it go? There it is. All right. Sorry, guys. Here we go.
Versus Garland and the consolidated case. Mr. Francisco.
Mr. Chief Justice, and may it please the court. Under the Act, one of America's most popular speech platforms will shut down in 9 days. That shouldn't happen for 3 reasons. First, TikTok Incorporated is a U.S. company speaking in the United States. The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok's speech. So the First Amendment applies.
Okay.
Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda, and its fallback that it seeks merely to prevent covertness makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people.
Yes.
Given that the government's data security rationale cannot independently sustain the Act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the president-elect, potentially moot the case. I welcome your questions.
Okay. So the general outline is it's a free speech issue. There are other ways that this could be handled, but instead, basically, they're suing to completely eliminate this app. Well, they call it divestiture. In other words, we're okay if somebody from the US owns it, but it's not okay because, like, what, 1% is owned by China or something like that?
I think it's a little bit more than, but yeah,
Because there's a Chinese owner, is basically it. Okay, so moving on. The next clip, we go directly into it, is actually Justice Thomas, and that is from 344 to 547.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that in its view reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok.
I'm going to pause it here because it's actually an interesting question, right? One of the things that we've seen consistently is that corporations seem to have more rights than people, right? Or at least as many.
yeah, there was a Supreme Court case.
Yeah,
yeah.
they just as many rights as people, which is a problem because people should have more rights than any sort of fictional entity, whether that's a corporation, business, otherwise, right? However, I think it's a valid question. So TikTok is not an individual. TikTok's an app. Is an app even like eligible for the same rights as people, as citizens?
That's a good question.
Maybe this is opening up something. Let's see.
You cannot use the algorithm that says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos's international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos's First Amendment rights. That would also violate the Washington Post's First Amendment rights because they're ultimately the one that's suffering the burden under that law because they have to go dark and close up their books.
Okay. Interesting way of looking at it. And I see what he's saying. I don't know if I necessarily agree.
Yeah.
But I see what he's going for. All right. The next little clip is from our favorite Chief Justice, John Roberts. Right.
I knew who you were going to say.
You began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds.
Okay. Pause briefly because one of the things that has been in contention is what's the big issue security wise with TikTok, right? And so the United States Congress apparently has found that the Chinese owner of TikTok, ByteDance, is under obligation from the Chinese government that says if we demand it, you have to give us this data. That seems to be my interpretation. Would you agree with that?
Yeah.
And I can see how that would be a problem. I can definitely see how that would be a problem. Now, on the other hand, are they getting any data that isn't already being tracked by Facebook, Instagram, Threads, all these other
True.
social media apps?
They're basically saying the U.S. government can track you, but not the Chinese.
Right,
Yeah.
right. Which, to be fair, as a United States citizen, I don't want either damn government tracking me
I don't
personally, but I guess I can see the argument. I don't necessarily agree with it, but I can see the argument for this is a national security issue. Again, don't necessarily agree with it. I'm not sure they're being 100% honest.
And with deep fakes, you got to be careful too to the Chinese to try to make something look like something happened when it.
You know, that's a fair point too. That is a fair point because there are no shortage of ways to make things look the way you want them to, whether that's via app,
with
deep
video
fake,
now.
video. Yeah, there's tons of stuff out there. No, really.
Are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters because even if China could...
Hold on. Okay, so yeah, I dispute that China has control, but I don't think it matters. I think it does matter. I think that's like a crucial part of the issue here, but let's give him a chance to explain.
Yes, Your Honor, I do dispute that, but I also don't think that it matters because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down.
Yeah, I didn't really agree with that argument.
Okay, that's an interesting argument. And it takes me a minute to get my head around it because I think I see what he's saying insofar as, all right, let's imagine, because we know, if you don't know by now that Bezos owns the Washington Post, you really should get caught up. But yes, Jeff Bezos owns the Washington Post. And the argument he's making is, let's say China kidnapped Bezos's kids and said, print what we want or you'll never see them again. And I hate to admit it, but he does make a good point insofar as forcing him to sell the company would be a violation. However, a disclaimer would not be a bad idea in that circumstance. And I think that's what he's trying to argue for. But I think there's a vast gulf between the analogy he gave and what's really happening here.
I don't think that was a good analogy.
Yeah, I don't think so either. Like I said, I think I see what he was going for, but wow. All right. So the next clip is actually Justice Alito at 1335. I had it. There we go. All right, here we go.
If I can break this down, suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that. All right. What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different.
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government of Qatar.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
because there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment. And if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Okay. All right. I see now the purported security threat that they're talking about. I understand it now. Again, do I necessarily agree? No, not necessarily. But at least I can now understand what they're talking about as far as this is a security threat. There's a threat to our national security. Okay. Why? Because what they're saying is not only can China exert control as far as give me the data, but they can also exert control as far as content. They can say, well, we're only going to put this out. Okay. All right. So we're going to go directly into Justice Neil Gorsuch giving his questions/statements.
Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
Somebody
we do.
has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay, and then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions,
Sure.
but I just want to understand what's before us. Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think, at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States, that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos.
I got
We
that.
understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows, first, what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
Removed or
reports.
restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things where I don't know what the accusation
I
is.
have other questions about the secret evidence in this case, but we'll get to that later.
Yes,
Thank you.
Your Honor.
Right. Okay. So, and I agree with them. It's hard to answer a question about redacted stuff. Like if you can't read what the accusation is or the claim, then you it's kind of difficult to respond to it. Okay. The next little bit is 2624 to 3133. This is Justice Alina Kagan. I'm going to say 26.
This is a foreign. This isn't what Justice Barrett says. It's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, you know, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition
Well, I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
Yeah. I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business product and travel reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, you know, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. You know, let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that as affecting TikTok, as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. You know, maybe ByteDance will figure out a way to like put this on open source, and then TikTok will be able to use the algorithm.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights. To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. Yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you. Okay. So the one thing I will say that's extremely interesting that he brought up is it harkens to this is too Republican or this is too Democrat, right? We've already seen the instance of that here in the US with X, Facebook, Twitter, all these companies that the Biden White House was harassing. Like Zuckerberg was on Joe Rogan. Did you see?
I did.
And he was talking about how the Biden White House was calling and screaming and cursing at his team to get stuff they didn't agree with off of Facebook. So how's that any different? And again, I want to be very, very clear. I consider China an adversary. I like the Chinese people. Chinese people are awesome, dude. But the Chinese government can go F themselves. So I'm not on the side of China here or anything. And I don't even fucking use TikTok. I want to be clear. The wife made me get an account for the show so that I could try to upload some clips, right, to try to be relevant. I don't use TikTok. The only time I use it is when she goes, here, watch this.
I don't use it at all.
There's a lot of that. Don't get me wrong. It's here, watch this. And, you watch and you're like, yeah. Anyway. But he does make a really good point insofar as we look at something like that and we go, oh, that's ridiculous. That can't happen, except it has happened. We've already had our government putting pressure on our social media companies.
That is true.
So we know a foreign government is even less likely to give a damn about doing that. And they're arresting people in the UK over memes.
Really?
Oh yeah, you didn't see that?
I did not.
Oh yeah. Yeah, they're arresting people over Facebook posts and memes over there. So yeah, to the UK, double dose for you guys. Yeah. And that's why, dude, the vast majority of the people who live in the UK nowadays if you catch them online, they are specifically addressing America, saying, do not, under any circumstances, give up your firearms. Because this is what it turns into. Look at fucking Australia, dude.
Oh, yeah.
They're nuts too now.
So, what about Canada?
Yeah, Canada, the UK, anywhere, basically. Yeah. The point is, though, I see what he's saying, and it's crazy that they're so quick. We know how this turned out, but they're so quick to jump on, quote, national security, but our government is just as guilty. Anyway, all right, so moving on. The next clip is at 35:47, and it goes to 39:38, and this is Justice Alito. Let's say 35:47. Close enough.
Incorporated. Justice Thomas, Justice Alito.
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens, and they said this is the worst offender, and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Okay, that's actually a really interesting question. All right. I got to give it to Alito. That's a thought-provoking question. If we were just talking about data, nothing else, and we're saying they're getting a whole bunch of our data, and that's the only concern, we're not talking about content, just data, would that be enough? Let's see what he says.
Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you posited.
But you're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say I don't want to prolong this too much. You say that.
So that's an interesting point. It specifically precludes or leaves out, pardons, e-commerce apps that have ties to China, aka Temu. What's the other one? The Wish. Alibaba or whatever, not Al Jazeera, that's a newspaper. The Alibaba shipping, you know what I'm talking about?
Yeah.
I don't remember if that's the name, but it's something like that. That's a good point, though. Those are okay. And I would argue they're getting a heck of a lot more data that way, financial data, than they are.
That is true.
I mean,
credit cards.
Yeah, I mean, there's a lot of data concealed in that. You're talking shopping habits, you're talking address, you're talking like shipping address, billing address, credit card data, bank data. There's a lot more dangerous data in that, I would argue, than watching some furries dance or whatever it is people do on TikTok.
This is not like ACARA. I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law. It didn't go after speakers at all. If you had a law in ACARA that said we're going to prohibit prostitution in bookstores only, then I think that ACARA would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict.
All right. Well,
that's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed for the purpose of narrowing in on what your argument is. I understood you to say that that would not be a solution to the problem, because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that would trigger at the very least intermediate scrutiny.
All right, thank you.
Okay. I'm not sure what a car is. I'm just going to say it. I have
I
no idea
don't
what he's
either.
talking about. Something to do with prostitution. If it was outlawed in bookstores, something about speaker. I'm not going to pretend I understand. So we're
It
just
was a
going to move on.
former case, so I'm not sure.
It probably has something to do. Here's the thing, right? Lawyers, especially lawyers that are former solicitor general, these people have their own language. I'm not an attorney.
No.
I don't pretend to be an attorney. I believe that every American should really listen to this kind of stuff and see what's happening at one of the equally powerful branches of government. We pay attention to Congress. We pay attention to the president. A lot of times, not too many people pay attention to the Supreme Court. And I think we should. So but I'm not going to pretend like I understand everything they talk about. A car, I don't know what that is. So moving on. So our next little clip is one of our favorite justices, Brett Kavanaugh. I like the dude. I think he's made some. I'm not being facetious here. Sometimes I'm facetious when I talk about John Roberts and
I know you don't like
ACB. She can, kiss my ass. Anyway, but I think Kavanaugh is coming along pretty well. I think for the most part, he's making some really good decisions as far as rulings go. But 44-12 to 48-49. 44-12. There we go, to 48-49.
Justice Kavanaugh?
Just on the data collection interest, I think Congress and the president were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic assessment by Congress and the president of the risks here?
Well, Your Honor, I'm not disputing the.
Okay, now that's a real concern. That is an absolutely real concern. So, okay, we're less to the hypothetical and more to the actual, okay, this is a threat. See what he says.
Risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the president were concerned about. You're just saying the means they chose to address that risk were incorrect.
So
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody, not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it, we go dark. essentially the platform shuts down.
Which happened.
Which actually happened. And then
They were down for like 14 hours.
yeah, and then they rebooted and had a little message thanking President Trump, which I'm sure just triggered some people, like absolutely triggered some people.
And then Trump signed an executive order yesterday saying that he's going to give TikTok an extension of like 75 days, I think it was.
Yeah, 75 to 90 days, something like that. So let me ask you this, right? Just your opinion. We talk a lot, and we've talked about it regarding student loans, right? The law is the law, and Biden went against the law by trying to consistently push through these student loans.
And he
forgiveness.
continued to do it up till he left office.
Up till the last minute. Now, with that in mind, do you think Trump is wrong by trying to end around a law passed by two other branches of government, technically, because Congress passed it, Supreme Court upheld it?
True. I don't like it. I think Congress should look at it again.
Yeah, I think it was an overreaction. I think, like the guy said, there were other alternatives they could have tried first. Not so extreme, like, for example, forbidding them from sharing this type of information. But
even though Biden did it, it doesn't make it right. I don't like anybody
going outside the law, right? Yeah, doing an end around. Yeah. So even though it saved TikTok for the short term, ultimately Trump is going against two branches of government here. We didn't like it when Biden did it. It's hard to justify it when 45/47 does it, right? Okay, so just another like minute and a half on this. We're going to 48-49, and then we jump ahead.
Unless there's a divestiture.
Unless there's a divestiture, unless President Trump exercises his authority to extend it by night, but he can't do that on January 19th. On January 19th, we still have President Biden. And on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an enormously—
What do you mean by shut down too? Can you just spell that out?
So,
if you
the app is not available in the app stores. That's at a minimum. But in addition, what the act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously—
Yeah. And I see why he was asking for that. And personally, that's probably what I would have said. Let's put this off for a little bit, give an injunction for like a week, let Trump take office, let Trump decide what he's going to do. But that's not what they did. No. Okay, so we're moving ahead a little bit, and this time we're hearing from Jeffrey Fisher. And that's 10107.
Do the case.
What's that?
The next person that's going to do the case.
Is that is that another member of the TikTok lawyer team?
I think he's ByteDance.
With ByteDance? Okay, let's see.
If I remember right.
10107 to 10234.
Mr. Fisher?
Here he is.
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal interests here.
Okay, so Jeffrey Fisher is an attorney for TikTok content creator Brian Fireball, which is why this is known as TikTok v. Garland and Fireball v. Garland, because it was a content creator who also sued to say, hey, if you guys take away TikTok, this is my living. This is what I do. And that's a fair point, because there are people who that was the entire life. wrapped up in TikTok. And I'm not talking about people who just sit there and scroll all day. I'm talking about people who genuinely pay their bills via the TikTok store, other methods, whatever, man, however you make your dollars. But there are people who legitimately made money from TikTok. And I think that personally is a much greater argument for putting a hold or keeping it than the arguments of speech, right? Because now we're talking commerce, and that's a whole, which I don't know if you know, but in the decision that the Supreme Court handed down, they never actually mentioned commerce in any of it. Did you see that?
Yeah.
Like, what do you think of that? Isn't that weird?
A little bit, because that's part of TikTok too. It's
right.
Not just weird videos with
that they just, yeah, it's not just a bunch of goofy videos of people, do, what is it called? I forget, dude. The wife knows all the TikTok terms, but like where you have the video and then there's the little video next to it of the person reacting to it. Like what is it? A chain or something?
I have no idea.
I don't know either, but she knows. You guys, if you guys watch, you're yelling at the screen right now going, no, listen, you idiot. It's this. I don't know. I don't watch TikTok, but
I don't either.
Okay. So, yeah, this is Mr. Fisher here, attorney for Brian Fireball.
The act directly restricts the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the act fails that test, and indeed any level of scrutiny under this court's case law, because the act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we've faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
Okay. That's a very valid point, dude. Very valid point. Let's face it. Other countries restrict speech, not us. And just because it might make you think, poorly of our leaders, well, maybe we need better leaders. Then if it's that easy to, you know what I mean? To I guess, undermine the public opinion of them. But all right, so moving right on is Justice Thomas and 102.35 to 104.43. And my camera's still frozen. I don't know why. Yeah.
I see.
Whatever.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country.
But I see what he's saying. Yeah, it doesn't address it, but it's definitely a consideration because if TikTok goes dark, this affects the creators.
The company is not here. With someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post-speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform, and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using that
particular
argument, you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, look, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X, or the current owner of Fox News, or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't...
Okay. All right. Let's see what he's saying. I think it's going to be less effective than he thinks. I can already hear it in Thomas's voice. Yep. Like, yeah, I see where you're going, and no, but just me. All right. So we have our favorite DEI hire next, which is Ketanji Brown Jackson. And 104.44 to 108.54. So a full 4 minutes and 10 seconds of her. Yay. No, I'm kidding.
Yeah,
to be fair, I don't know in this particular circumstance because I haven't listened, but to be fair to her, in the past, she has brought up some really good points. Is this one of those cases?
If I remember right, no.
It's okay.
But
Here we
we'll
go.
see.
We're listening to her anyway.
It's been a couple days since I've seen this.
No, it's all good. Here we go.
Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States. I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right. So I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it terrorism? Is it where our battleships are located?
Justice Kavanaugh presented a number of potential risks, right? With foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it.
Are you looking at the horrible? What is it? The captioning?
I did.
Oh my God. If you guys aren't seeing this, it's unique, man. Yeah.
I didn't catch that before.
Yeah. It's okay.
More likely that people would turn it today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now, there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Okay, that actually is a very interesting way that he put it. And that was, it exceeds, basically it becomes unconstitutional because it seems to be focused less on foreign adversary and more on content because, like he said, the current algorithm is banned regardless. So even if ByteDance is divested, they still can't use the current. What? That's something sounds fishy as hell there. Would you agree with that?
Yeah.
All right, moving on. We're going to go right into Chief Justice John Roberts, who, for those of you new to the show, he's actually from LaPorte, I heard.
He was born, I think he was maybe not born here, but I think he
graduated LaPorte High School.
Yeah.
I do know that. And apparently is good friends with Tom Dermody, mayor of LaPorte.
Isn't that interesting?
Mm-hmm.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy.
Bullshit.
They're not saying TikTok has to stop. They're saying that the Chinese have to stop controlling TikTok.
Just so you guys know, we're going to 112.18. And you guys can find this. This is C-SPAN, and it's Supreme Court hears case on TikTok ban. Go ahead.
It's on YouTube.
On YouTube, right. Sorry, C-SPAN on YouTube. Right.
So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate the where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the first part was not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got all the information, whatever algorithms they want, that has access to the personal information, or at least information that is not readily available about 170 million Americans. And
that's the voice of a man who has already made up his mind. Just saying, listen to it, whether he received marching orders or whether he came to this decision on his own, none of us will ever know for sure. But that's a man who has already decided this is going to get upheld. That's my vote. That's just my opinion. You guys listen to his voice and make your own determination, as I urge everyone always to do. But it sounds to me like,
when information that is not readily available about 170 million Americans, and whether they're going to use it in 10 or 15 years when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says, what we're really worried about is sowing doubts about US leaders, et cetera. So let me turn then to data security.
Yeah, which in and of itself, like the United States does that shit ourselves, dude. Like Voice of America, all these other like radio stations that are run by the United States government in foreign countries, literally talking shit about these foreign countries and the leadership. We do it. Now, does that mean it should be allowed here? Not necessarily, right? But we know how fragile the ego is of most of our leaders. So they don't like it when you tell the truth about the shitty job they're doing running this country or this state or local or whatever, wherever their sphere of influence is. All that said, I think there's a compelling case here that national security could conceivably be at risk. And I think that's why they ultimately decided, right? But I don't think it's the compelling argument that a lot of people believe it is. Just my opinion. But we're about halfway, so let's get on it. I'll talk less.
Yes, there were various congresspersons, and in the record that we have in the DC Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that is a valid governmental interest.
Right.
So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it and every bit the connection?
Does Congress have to go?
That's what we talked about earlier. Yeah, is conveniently, if they're so worried about data, then why are they leaving out Temu and Wish and these other?
And that's a fair point.
And now that this has been upheld, though, maybe Congress will decide, you know what? We're emboldened. Let's go after all of them.
They could.
And it's possible. But, and again, I want to make sure my viewers understand, I'm not a China apologist. China sucks, right? Especially with the Chinese steel and all the garbage ass products that they steal our intellectual property, then turn around and make a copy of it, which is worse. So, and
the way they treat their own citizens.
Exactly. Yeah. I mean, the Uyghurs and all these other people that are literally living in slavery, F China. But at the same time, I do believe that the attorney's making some compelling arguments, because you can't just have because they make us look bad as your argument. Like, what? All right. We're gonna go right into Kavanaugh at 1:12:19, and it goes to 1:12:40. So 20 seconds of Kavanaugh. You ready? Ready? Here we go.
All or nothing on that? I mean,
It doesn't have to go all or nothing.
they isolate a particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying it would.
Okay. Yeah, that's right. Maybe they haven't gotten to it yet. Maybe they will. All right. So we're moving on to part 3, guys. And we're going to start at 1:36:24. And this goes to 1:38:55. Now, we're going to hear now from Elizabeth. I'm not sure how you say her last name. Forgive me. Preligar. She is the United States Solicitor General. I don't know that much about her other than she has no fucking clue what she's talking about when it comes to guns. We've proven that, but this is not a gun case. So, all right. 1:36:24 is what we're looking for. Close enough. And here we go.
General Preligar.
Mr. Chief Justice, and may it please the court. The Chinese government's control of
That's a much better
TikTok.
picture of her than the one that I saw. She's a lot better looking than the one that I saw.
Really?
What the hell, dude? Yeah. Bruh. Anyway.
Mr. Chief Justice, and may it please the court. The Chinese government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing vast quantities of sensitive data about Americans and by engaging in covert influence operations. And no one disputes that the PRC pursues those goals by compelling companies like ByteDance to secretly turn over data and carry out PRC directives. Those realities mean that the Chinese government could weaponize TikTok at any time to harm the United States. TikTok collects unprecedented amounts of personal data. And as Justice Sotomayor noted, it's not just about the 170 million American users, but also about their non-user contacts who might not even be engaging with the platform. That data would be incredibly valuable to the PRC. For years, the Chinese government has sought to build detailed profiles about Americans, where we live and work, who our friends and coworkers are, what our interests are, and what our vices are. TikTok's immense data set would give the PRC a powerful tool for harassment, recruitment, and espionage. On top of that, the Chinese government's control over TikTok gives it a potent weapon for covert influence operations. And my friends are wrong to suggest that Congress was seeking to suppress specific types of content or specific types of viewpoints. Instead, the national security harm arises from the very fact of a foreign adversary's capacity to secretly manipulate the platform to advance its geopolitical goals in whatever form that kind of covert operation might take. The act addresses the threat of foreign adversary control with laser-like focus. It requires only divestiture of TikTok to prevent Chinese government control. And that divestiture remedy follows a long tradition of barring foreign control of U.S. communications channels and other critical infrastructure. So no matter what level of First Amendment scrutiny applies, this act is valid because it's narrowly tailored to address compelling national security threats. Now, my friend Mr. Fisher just emphasized, and I acknowledge, that millions of Americans enjoy expressing themselves on this platform. But the important thing to recognize is that the act leaves all of that speech unrestricted once TikTok is freed from foreign adversary control. The First Amendment does not bar Congress from taking that critical and targeted step to protect our nation's security. I welcome the court's questions.
Okay. Couple of interesting points here. For one, I'm not sure who to believe when she's like, oh, they're not worried about the content. I would argue they are. But at least, especially if the previous guy who was talking, I mean, he called the brief itself and said, there's 2 parts here. The first one is due to content. And so right? But the part that makes a heck of a lot of sense that she brought up is, yeah, okay, maybe you, the wife, right? Let's take the wife. She's got the TikTok. She's always watching the TikTok, right? Well, when you install TikTok, the first thing it does is ask if it can look at your contacts so that you can find other people who use TikTok. Maybe that's what it does, but maybe not. And unfortunately, there's no way to know for sure. And the potential is assuredly there for ByteDance to utilize all of this information that they're gathering on Americans for nefarious, negative purposes, right? It's definitely a possibility. And I think that's kind of what they're touching on here. But it goes into Justice Thomas, and it's 138.56 to 139.59.
Is there any difference between content manipulation by a non-U.S. company as opposed to a U.S. company? I didn't hear Mr. Fisher make a distinction between the two.
Yes, and I think the important thing to recognize is that the act here is targeting covert content manipulation by a foreign adversary nation. Now, I understand my friends to say—
What difference does that make?
The difference is that there is no protected First Amendment right for a foreign adversary to exploit its control over a speech platform.
The difference between covert and non-covert.
Right. So I think that Congress's concern with the covert operation was that a foreign adversary could effectively weaponize this platform behind the scenes in order to achieve any number of geopolitical goals. Here are some of the examples that come to mind. One of the pages out of the playbook here is for a foreign adversary to simply try to get Americans arguing with one another to create chaos and distraction in order to weaken the United States as a general matter and distract from any activities that the foreign adversary might want to conduct on the world.
So basically, the same thing that's happening in the United States with the Democrats is basically not just the Democrats, but the let's call it the extremes of both sides, right? They want us arguing. They want us fighting. That's why, Donald Trump, according to these people, is the end of the world and all things evil and this and that and the other, right? They want us arguing. Speaking of, did you see that ridiculous service that Trump attended in Washington with the super woke pastor? Did you see it? She's talking about transgenders being afraid and all this crap. Did you see that? I'll show you after. Once we finish this really briefly. It was nuts, dude. It was nuts. And JD Vance's face was amazing. That guy cracks me up. He is a worthy MAGA successor in my opinion, but
we'll see.
We'll see. Exactly. So far, let's say that so far he's entertaining. All right. So we're moving right into Elena Kagan, 140 to 142, 2 minutes exactly. Here we go.
By covert, though, I mean, is covert just mean it's hard to figure out how the algorithm works? Because we could say that about every algorithm.
No, the covert nature of it comes from the fact that it's not apparent that the PRC is the one behind the scenes pulling the strings here and deciding exactly what content is going to be made to appear on the site. And another way that
it's just because we don't know that China's behind it. That's what covert means.
Well, I think
it doesn't have anything to do with the difficulty of figuring out what the algorithm is doing. No. It's just because people don't know that China is pulling the strings. That's what covert means.
What it means is that Americans are on this platform thinking that they are speaking to one another, and this recommendation engine that is apparently so valuable is organically directing their speech to each other. And what is covert is that the PRC, a foreign adversary nation, is instead exploiting a vulnerability in the system.
Well, if that's all it means, that like people don't know that China's behind it, like everybody now knows that China is behind it.
Right. No, but it's the specific content that's being manipulated would be unapparent. And so I think
that's true of every search engine. I mean, you can take any of these algorithms, whether it's X or whether it's, you name it. What are the new ones? Blue Sky. I mean, none of these are apparent, right? You get what you get, and you think that's puzzling,
right?
And it's all a little bit of a black box. So you can't just mean it's a black box. It's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it. I mean, honestly, really, like everybody does know now that there's China behind it.
Right.
So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening. And therefore it doesn't guard against the national security harm from the operation itself.
Isn't that
Okay. So I see Kagan actually made a great point, which is all this already exists, right? As far as the For You page, right? The algorithm, that's what they're talking about. It's the same thing on YouTube. It's the same thing on Facebook. These algorithms basically pick out what they think you'll like in order to generate engagement. That's all.
I was seeing if I was frozen.
No, I think you're still good. Yeah, it's just
you're
my
still-
camera.
you're still frozen.
Yeah, I got to get a new camera. I'm working on it, guys. One thing at a time. Jeez. Anyway, I'm just kidding. I'm just giving you guys a hard time. All right. So we're going to go right into Neil Gorsuch, and that's 142.01 to 144.07. Here we go.
a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China.
Right.
In case anybody were left in doubt after today.
In case you didn't know that.
About that possibility.
Right.
So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is—
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and
they think you're stupid. Let's make sure you understand that the government official position is that Americans are stupid.
And that clip right there was the reason why I thought it was going to be 8-1, was because Gorsuch sounded like that he wasn't going to upload. But he decided to go with the majority.
Apparently.
Yeah.
had a sign that said 1 of 1 million products in this store causes cancer, that is not going to put you on notice about what product is actually jeopardizing your health. And I think—
Okay, that is a stupid, stupid comparison.
Yeah.
That's a
That was a
stupid
weak
example.
argument.
Yeah.
I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean, every editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how, but they're generally aware, and we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but we're not arguing about the compelling interest. We're arguing about the tailoring.
Right.
Yeah. Yeah.
That was a weak argument.
It was a very, very weak argument. Again, like, I don't know, because so much of the shit is redacted, right? That's one of the issues with this particular case, is that Congress looked at a whole bunch of stuff, had their hearings, issued their decision, and redacted a whole bunch of it. So we, the people, can't even look at this and go, oh, yeah, that makes sense. We have to go, well, Congress said we're better off without it, because Congress really knows what the hell they're talking about. Give me a break. I'm going to tell you, that's my biggest issue with this, is that Congress had anything to do with it, honestly, but I get it. Okay. We're going to 148.06. Wait a minute. Yeah, 148.06, which is Justice Alito.
Hold on. Too far. Did you say 148?
148.06.
Okay, there.
I'm at
I
148.07.
thought you said 46.
Yeah, I'll back it up.
Suppose that TikTok had no connection whatsoever with any foreign government.
Okay.
It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
It's a really good question, and I want to point out something that I forgot about before when they were talking about foreign actors being able to buy up newspapers and radio stations. Apparently, it's okay for Soros to do so.
True.
Because the groups that he controls are buying up tons of them. And
Radio
he is not a
stations,
U.S. citizen.
Yeah, radio station.
Yeah, he's a piece of shit. But that's, a whole other thing. All right. Yeah, it's okay in that case, right? Because it's Soros. But China, no.
I think there would be a first order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control.
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
How do you feel about that? It's okay if a U.S. company does it, but a Chinese company, absolutely not.
Yeah.
I think we're in the weeds, dude. When it comes to like the First Amendment and the protections therein, I don't know if I necessarily agree with the way they're leaning. Obviously, they decided it, but I don't know that I agree with the reasonings. Like, I don't know. It's on the one hand.
This case.
What's that?
I'm really mixed feelings about this case.
Me too. On the one hand, I agree that there's a need to protect. There's a need to protect Americans when it comes to our data, whether it's harvesting, whether it's, being used potentially later on, but there are no protection anywhere for American social media companies.
True.
TikTok, Twitter, Facebook, Instagram, Blue Sky, all these other bullshit ones.
And the government can take our data.
Exactly. They buy it. Yeah. As a matter of fact, we talked about this before, how the NSA isn't allowed to directly harvest your data, but they can buy it. They can buy it in a bulk order from social media companies. So whenever something's free, you're the product.
Or when you do the frequent shopper card stuff too, they buy that stuff too.
Yeah, so they know what you're buying. You got your little Owls card or your Kmart card or whatever there is around in your area. You use your frequent shopper card, it tracks what you're buying. That's the point of these things. So that they know what coupons to send you. They know what you're going to buy. They can generally look at how often you come in, and they start to kind of count on those sales to a degree. It's quite involved, dude. I remember the advent of the frequent shopper card, and people were like, "Oh, that's so cool." And my grandfather was horrified, absolutely horrified. Said, "Tell my grandmother, under no circumstances are you to sign up for any of that stuff." And she's like, "But the coupons." And he's like, "But the data." You're giving them. And he is. He's absolutely right, which really annoys me sometimes, because my grandfather being right was always like one of the things that would infuriate me. But yeah, he was a smart man, but not very well educated. So like intellectually very, very smart, but when it came to words and spelling, he wasn't so great at that. So that's when I was a little kid, I would lord that over him. It kind of caused some friction.
I see.
Just a little bit.
Did he live in Indiana or Louisiana?
No, he lived in Indiana.
Okay.
This was my grandfather, Bob.
Okay.
And he lived actually right around the corner from here, at the corner of Risky and Michigan Boulevard. You know how they have that bank right there? Right next to that bank is the house that they owned for like 30 something years. And then my grandmother sold it after my grandfather passed, and she moved to Ohio.
Okay.
Yeah. And then, married someone, he passed, and then she just died right before Christmas. So, all right. So this was, 150.02. We're going 150.02 to 151.14. Coney Barrett. All right, here we go.
Jennifer, sorry.
I'm sorry.
I just wanted you to respond to Mr. Fisher's argument about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance did not itself have First Amendment rights, that Americans would have a First Amendment right to receive that information in the Lamont sense.
Yes, so I think that Lamont reflected a principle that there can be a right of American listeners to receive information. And if Congress is directly regulating that based on disagreement with the speech that's being sent into this country, that's obviously going to trigger heightened scrutiny under the First Amendment. But here, I think the users have to be asserting a different type of interest, because what Congress was safeguarding against was not the ability of TikTok to continue to operate or the users to post content. It was focused only on foreign adversary control. And so the users would have to demonstrate that they have some unqualified First Amendment right to post on a platform that's controlled by a foreign adversary, which could use that access to then threaten our nation's security by gathering data on tens or hundreds of millions of Americans, and also use it for covert influence operations of whatever form. And I don't think there's a First Amendment right to do that.
I was trying to think.
Okay. Last real pause. We're going to jump into the last little clip here, which is Justice Kagan. But before we do, I think that we're seeing kind of the last little gasp of the censorship complex, trying to do what they can. Because one of the things I find absolutely fascinating about this particular case is that you guys notice this TikTok ban didn't even really come up until certain content was shown on TikTok. I'm just saying, look into it. I'm not even going to steer you when I talk about what kind of content. Look it up. Look it up and see what happened around that time where they started talking about banning TikTok. TikTok's been around for years.
2000.
Let's see. When was TikTok?
I want to say 2018.
When was TikTok made? September 2016 was released by ByteDance.
2016?
2016.
Really?
Yeah, September 2016. So interesting.
I did not know that.
Yeah, so it's been around a minute. It's been around a little minute. So
9 years. Nearly 9 years.
All right, so we're going to jump into the last clip, 151.15 to 154.58. This is Justice Kagan. And guys, stick around after, because I think you're going to want to see Shawn's reaction to this clip I'm talking about. Here we go.
Of whether there's a historical analog here, and this is what I came up with, and you can tell me whether it's fallacious. In the mid-20th century, we were very concerned about the Soviet Union and what the Soviet Union was doing in this country.
That is
true. The Communist Party of the United States at that time was integrally attached to the Communist International, which was essentially a Soviet operation, right? So if Congress had said, oh, it's very nice, we can have the Communist Party USA, but it has to divest, it has to completely divorce itself from the Comintern and from any international ties that it has, do you think that that would have been absolutely fine? And so if the answer is yes, it would have been fine, it's just like this case. Or if the answer is no, why is it not like this case?
That is a very interesting question. It is a very interesting, and it's very thought-provoking, because if you're talking about, via mail order, really, but it's the same concept. You're talking about information. You're talking about data. This person are going to send their address and all that other stuff, right? They're going to talk about their friends. They're going to have these little meetings with their little commie friends, right? What did they call them back then? Pinkos, right?
Okay.
Pinko commies or something. I don't know all the old timey.
Yeah, I have no idea.
Yeah, but anyway, that's an interesting point, because obviously the Communist Party was a direct subsidiary of the communism present in the Soviet Union at the time. Is it different? Is the same? You've seen this already, so it's not like you haven't heard what she says. But my argument, if I was arguing in favor of the ban, then I would say, oh no, it's different, because if I was in favor of basically keeping it around or against the ban, then I would argue that, oh yeah, this is the same thing. It's banning free speech. Let's see what the Solicitor General says.
So I guess I think I would need to know more information about how the international organization is able to exercise control over the American affiliate. And if it had the capacity, for example, to, in an unqualified fashion, gather data from that affiliate in a way that was going to jeopardize our nation's security.
Well, I'm talking more about sort of the content. Let's put the data collection piece of this aside, which seems not very pertinent to my 1950s analog. But, very concerned about the kind of speech that the Communist Party was making in the United States. And it turns out that that content was pretty well scripted someplace else.
Yeah. I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're a little bit, I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress. And our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Okay. And as much as I may like go back and forth as to whether like, my camera's still frozen, ignore it.
Yep.
Whatever. You still hear me, so that's what's important because my voice is greater than all. I'm just kidding. No, there's a good point here insofar as we don't want China to have unrestricted access to all of our data. It's that simple. However, at the same time, I think this was a bit of an overreaction. I think a disclosure of some sort, a notification that you have to click, that you have to read, right? You can't just accept. You have to like look at it and scroll down. Let's face it, people don't read this crap, but that's whose fault is that? True. Like, I mean, when you put, hey, China has access to your data and can use it at any time. I mean, just saying. All right. So a couple things that I want to show you briefly.
All right, real quick.
So this one.
Yeah, I didn't see this yet.
Okay. So let me let me show you what we're dealing with here. Okay. So let's go back to
attack Trump. I haven't even heard about this.
Okay, watch this. This is wild, man. Like this is wild. All right, here we go. This was today.
Let me make one final plea, Mr. President. Millions have put their trust in you.
Tiffany knows what's
And as
up.
you told
Okay.
the nation yesterday, you have felt.
Do you know which one's Tiffany?
Yep. I see her between Melania and
I was
JD.
just asking because I actually didn't know. Like
Okay.
I just
Yeah, I
had to
know
be
who that
like, no, her. Watch JD's face.
Okay.
Melania. Woo! Just check out the faces, right?
I think it's harder on the family when they attack Trump than Trump himself.
I agree.
I don't think
but-
Trump really cares.
No, he doesn't, dude. At this point, but watch this.
Okay, I'll watch it.
The providential hand of a loving God. In the name of our God, I ask you to have mercy upon the people in our country who are scared now. There are gay, lesbian, and transgender children in Democratic,
look at JD.
Republican, and independent families.
She's not even looking at him because my wife said that would be me because I would know looking at you, your facial expression would get me going some kind of way.
Yeah.
Families, some who fear for their lives. And the people who pick our crops and clean our office buildings, who labor in poultry farms and meat packing plants, who wash the dishes after we eat in restaurants and work the night shifts in hospitals. They may not be citizens or have the proper documentation.
That's racist.
But the vast majority of immigrants are not criminals.
After hearing her use every single immigrant stereotype ever. Yeah.
That's racist.
But the vast majority of immigrants are not criminals. They pay taxes and are good neighbors. They are faithful members of our churches and mosques, synagogues, wadara, and temples. I ask you to have mercy, Mr. President, on those in our communities whose children fear that their parents will be taken away, and that you help those who are fleeing war zones and persecution in their own lands.
Yep.
to find compassion and welcome here. Our God teaches us that we are to be merciful to the stranger, for we were all once strangers in this land.
Man, what the fuck is you talking about?
What the fuck was that?
I'm sorry, man. No, I wasn't thinking about it when I did it.
Wow.
Yeah,
you might
man.
not like the president, but you should definitely respect the office.
Right. Like, are you serious, my guy? Like, what was that?
I've seen a lot of people think that Trump's, and I don't know where that comes from. Like that he's going to go after the LGBT.
Yeah.
I don't know where that came from because he is probably one of the most pro LGBT rights Republican president we've ever had.
Yeah. He's way cooler with that than I am. I'm just saying, like, way
maybe
cooler.
not so much transgender with the sports because he has talked about that.
Yeah.
But he has never mentioned lesbians or gays or anything like
that. He's had several people in his cabinet that were the first openly gay. What was his name?
He was the national security advisor.
Yeah, I can't think of his name. I follow him on Twitter. Smart dude, man.
He is.
Super smart
I don't care.
dude.
And I think Trump feels that way. I don't care what you do.
That's
just
what
don't throw it in my face.
Exactly. Did you see about the Elon salute?
I did.
Did you see that? Okay. All right. That's it. That's it for tonight, guys. We got pretty close to 2 hours. It's like 2 hours and 30 plus minutes for the entire hearing. If you guys want to, watch the whole thing, by all means, go do so. But I think we've touched on the most important parts of it. And unfortunately, they made the decision. We'll have to see what happens from there. But there's a lot, I think, that's still coming. Not just in regards to that, but just in general, I think that there's a whole lot of stuff that's still going to happen. Let's face it, old boy's been prez for a day. I think we're just getting started, man. I think he's about to kick stuff into high gear, and we're going to have to really focus and pay attention because, wow, it's going to get wild.
On the first day, he did like 200 executive orders.
Yeah, which very, very briefly, overall, positive, neutral, negative, or confused.
From what I've seen, I don't want to say all 200 because I haven't seen all 200. Yeah. But mostly positive.
Okay.
Like he took us out of the World Health Organization, which I was fine
did
with.
You see the WHO's response?
I did not.
They got on Twitter and cried about how they help protect the U.S. and the U.S. has been critical and we're gonna still shut up.
And he took us out of the Paris Accord, which I liked.
I'm giddy about that. So overall, man, I'm really looking forward to the second term. I think it's going to get buck wild. Personally,
I think so too.
Yeah. Did you hear Vivek no longer in Doge? Why?
He wants to run for governor of
Ohio.
Ohio.
How do you think that's going to work?
I don't know.
Think
it's going to be. I don't know.
Wife made a good point, which was imagine trying to beat that guy in the primary. Like, good luck. Everybody knows who Vivek Ramaswamy is at this point.
And Ohio is okay. I'll let you finish.
Go ahead.
I was going to say he might get it because Ohio, it used to be a toss-up state, but it's really a Republican state now.
Yeah, it has definitely snapped back to
Ohio and Florida.
Mm-hmm. Yeah, other than the certain cities that they're trying to bring in voters, Springfield, etc. It's very red. Ohio is very red. You're especially once you get outside the cities. Holy cow. All the Trump signs I saw while driving through rural Ohio, dude, it was just like Indiana.
I don't think it's quite as red as Florida and Indiana.
No, not
but
quite.
It's red.
But it's very red. Yeah. All right, guys. Sam's, hey, good to see you. Hope you're doing good. We'll talk to you guys again real soon. I have some stuff that I'm trying to get done, but I'm going to do my best to make sure you guys have some quality content and at least some interesting things to laugh at. So see you guys tomorrow. Hope you're doing well. And with that, God bless you. God bless Indiana. And God bless the United States of America. Hope you have a great evening. Good night.
If you'd like to support the show, please visit our Patreon at patreon.com/Dion's Daily Dose. This has been Dion's Daily Dose, hosted by Dion Bergeron. Executive producers, Shawn Holmgren and Michael Beebe. Copyright 2024. Dion's Daily Dose, all rights reserved.